Get ready for the dictation. Start. Thus, from the conjoint reading of the amendment provisions of Order 6th Rule 17 CPC and the law laid down by Apex Court in the aforesaid cases, it is abundantly clear that the trial court has to be cautious while granting or rejecting an amendment once the trial commences. Though it is a settled law that the court should be liberal in granting amendment so as to avoid unnecessary complication and multiplicity of litigations, but once the trial has commenced, the party making an application for amendment has to spell out clearly the cause which had prevented it from bringing the amendment prior to the commencement of trial, and also disclosing the reason that despite due diligence it was not in the notice of the party, and only when the said fact came into the knowledge of the party claiming amendment that such application was filed. Now coming to the case in hand, it was on 10/12/2014 that the plaintiff revisionist had filed a suit for damages violating the terms of the lease agreement. The plaintiff was fully aware that the lease agreement had come to an end on 31/10/2014, and the remedy for evicting the defendant from the premises let out was already available to him at that time, which he had not chose to claim. In fact, the plaintiff only wanted damages for the occupation of the property by the defendant at the rate of rupees 2,000 per day, and had tried to enforce clause 3C of the lease agreement. In the meantime, the defendant in the present case had filed suit number 1048 of 2015 before Civil Judge Senior Division Gorakhpur, claiming relief that the plaintiff herein may permit the defendant to remove his batteries and inverters stock, which was still lying in the premises in dispute, on which the lock of the plaintiff was hanging. It was only in the year 2018 that notice under section 106 of Act 1882 was served on 31/1/2018 and 26/2/2018 for arrears of rent and ejectment from the premises in dispute. In the meantime, issue numbers 8 and 9 were decided by the court below on 7/2/2017 and 3/3/2017, and the plaintiff was already examined before the court below. There is no whisper as to why there was delay on the part of plaintiff in filing amendment application on 11/12/2018. From perusal of amendment application paper number 59/2, it is clear that only amendment has been sought in the plaint claiming arrears of rent and ejectment from property in question, and no compliance of proviso to Order 6th Rule 17 CPC has been made by plaintiff while making such application. The plaintiff revisionist not only failed to adhere to the proviso to Rule 17 of Order 6th CPC by stating reason that despite due diligence, the fact pleaded was not within the knowledge and could not be raised earlier, but is also barred by Order 2nd Rule 2 CPC, as the suit filed by the plaintiff did not include the whole claim which the plaintiff was entitled to make in respect of the cause of action. The present amendment is a fresh cause of action, and by the amendment, the suit for damages cannot be amended. Moreover, the relief which is being claimed by the revisionist through amendment was available to him when the suit for damages was filed by him on 10/12/2014, as the lease agreement had already expired on 31/10/2014, and the plaintiff could have claimed the relief for arrears of rent and ejectment, but he chose to press the relief of damages on the basis of Clause 3C of the lease agreement, which had come to an end on 31/10/2014. Thus, this court finds that post amendment in Order 6th Rule 17 CPC, which was brought in the year 2002, the party seeking amendment has to adhere to the proviso while making an application in case of commencement of trial. It is not disputed to either of the parties that after framing of issues in the year 2016, two issues had already been decided and the oral evidence of plaintiff has already concluded. It is well settled that Section 17 of Act 1887 provides that provisions of Code of Civil Procedure is applicable in the matters dealt by the judge small cause court under the Act 1887. Considering the facts and circumstances of the case, this court finds that the trial court had rightly rejected the amendment application of the revisionist, as it does not disclose any reason for filing the same post commencement of trial, which is against proviso to Order 6th Rule 17 CPC. No interference is therefore warranted in the impugned order. Revision fails and is hereby dismissed. Stop.